for Legal Eagles exclusively. Barta Kalinski and Professional English. Intellectual Property Law Language Training for IP Student 2020. Counsel Marcinkowska, a senior associate practicing Barta and Kalinski, has been inundated with COVID-19 related work. She has assigned an important new client to Adrianna Żyrek, a junior associate in the law firm. Help Adrianna to prepare for the first video call with her client. The facts of the case are as follows. The Ministry of the Newest Technologies and Artificial Intelligence ordered new software for the maintenance of its internal processes. Implementation of the software was commissioned to the company CunningFoxes after the public procurement procedure was successfully conducted. The agreement concluded with the CunningFoxes stipulated, inter alia, that, quote, the contractor transfers onto the Ministry economic copyrights and the works created under this agreement in all the fields of exploitation, in particular in the fields of exploitation indicated in Article 50 of the Acts on Copyright and Related Rights, Section 12. Unquote. Moreover, the preamble to the agreement stated that the main aim of the agreement is to grant the Ministry all copyrights in the software and its documentation, including the rights to modification, development and maintenance of the software, both by the Ministry individually and by third parties acting on behalf of the Ministry. After the implementation of the software, the Ministry concluded a separate agreement concerning provision of maintenance services with another IT company, ITexperts. This company asked the Ministry for an assurance that they may modify the software and use such modifications in a legal manner and without prejudice to the rights of third parties. Additionally, ITexperts asked the Ministry to provide them with up-to-date source codes of the software, and they pointed out that without those source codes, they would not be able to provide maintenance services. The Ministry prepared a written statement for ITexperts in which they declared that the Ministry has full copyright in the software and its documentation, including the right to modification without any limits and right to exercise derivative rights. They assured ITexperts that they should be able to render maintenance services in a manner that does not infringe the rights of third parties, including producers' rights. The Ministry also issued a letter to CunningFoxes in which they asked them to hand over the source codes of the software, but CunningFoxes refused to do this, stating that there was no such obligation in the agreement concluded with the Ministry. They also stated that they were solely entitled to provide maintenance services or to do any modifications of the software whatsoever. Evaluate whether the statement of CunningFoxes has merit. Now, over to you. Barta Kalinski represent the Ministry in this dispute. What legal issues should Adrianna discuss with her client? Answer the following questions to help her prepare. 1. Is Article 50 of the Act on Copyright and Related Rights relevant to this case? 2. Were the rights to the software effectively transferred under this agreement? 3. What influence will the preamble have on the determination of the rights of the parties? 4. Is the concept of the lawful acquirer applicable in this case? 5. Can the ministry modify the program? If yes, then to what extent? 6. Is the ministry entitled to the source code? 7. Has the ministry lied in the statement issued to ITexperts? Thank you. For Legal Eagles exclusively.